Does the law say daughters, whether married or not married, can also be given land? Have you subdivided land and given yourselves title deed to the exclusion of your sisters? Those title deeds will be revoked. The sons who go hiding and lying that they were born only sons, there was no daughter, your time is up. The title that you have will be revoked. Everybody is equal before the law. I know the traditionalists, the male chauvinists who think that daughters cannot inherit. Your time is up. You either pack and leave and look for your country, because the Kenyan Constitution provides for equality of sexes. From Court Helicopter, we have told you it is now very clear all children are equal. No child is a child of a lesser God. Welcome to Court Helicopter Explainer, where we are dealing with a controversial issue that we did yesterday, that one cannot sell ancestral land, and one cannot deny his children from inheriting the land. Parents are up in arms. Bramwell was almost being clobbered, and Cyrus and Vivian, because they were being asked, how can you force me to give my son that land? When they were being asked by women on the streets of Nairobi all over, what about us? What about us? You never talked whether us as daughters we can inherit the land of our fathers. Kwani sisi sio watoto wa baba? Why? So Bramwell, Cyrus and Vivian had to run away to look for me to come and look at the law and get, does the law say daughters, whether married or not married, can also be given land? Leave alone daughters. A married woman who has gone, he has been given land, his husband, her husband is a super rich man. That is the wife of Lawyer Omari, is a lawyer. Then my wife goes back to their home to ask for land. Her brothers never went to school. Her brothers ride on a border. The husband has given her V8. She stays in Lavington. Her children go to the topmost schools. Yet, the law says that she must inherit the land of her father. That is not acceptable. So our crew from Court Helicopter has been fought hard by women to get the law that protects the daughters from the brothers. Another question, can you imagine you are a brother? You are there at home. Your sister got married. When your father wants to give you land, your sister comes and says she also wants land. Can you allow your sister to get land, yet she has thousands of land in Kitale where she got married? She has a lot of property where she got married. All that said and done, our crew, Bramwell, Cyrus, and Vivian, have done a tremendous research and found out that that question was brought before the Court of Appeal in the year 2002. Remember, that time there was no Supreme Court. There was no constitutional, the new constitution. This was a question that was brought before Justice Omolo, Justice Okubasu, and Justice Waki, all of them judges of the Court of Appeal. This was the apex court. So this is what happened in this matter. Let me read. This is a succession matter relating to the estate of Joseph Stephen Rono Rono, who died intestate without a will on 15th July 1988 at the age of 64. He was a farmer in Uasin Gishu. At the time of his death, he left a sizable number of properties, both movable and immovable. He was also survived by 2 wives and 9 children, into brackets, 6 daughters and 3 sons. In the probate and administration course number 40 of 88, the High Court in Eldoret granted letters of administration to the 2 widows and the eldest son without objection from the other members of the family. Disputes, however, soon arose about the distribution of the assets and liabilities of the estate. The questions went to the High Court, and the question before the High Court was whether what law should apply. Paragraph 12 says the deceased belonged to the Keiyo subtribe of the Kalenjin community, and the deceased lived with his 2 wives and children in one farmhouse and treated all of them equally. So the question before the judge was, how do you distribute this property? There are daughters. Daughters are more. There are 6. Sons are 3. One wife has only sons. The other wife has only daughters. What did the High Court say? In arriving at what is called its own independent distribution, the Superior Court considered both customary and statutory laws on succession. It made a finding that the deceased was a Marakwet, although the evidence was that he was Keiyo. The Elgeyo subtribe, also referred as Keiyo, are listed in the same chapter as the Marakwet and the Tugen in Cotran, the Restatement of African Law, which the Superior Court referred to as for the proposition that the pattern of inheritance was patrilineal, and that in polygamous households, distribution was by reference to the house of each wife, irrespective of the number of children in it. Daughters receive no share of inheritance. So the judge said, under the Keiyo traditions, daughters receive nothing. This is the reasoning of the judge. And here she says, the situation prevailing here is rather peculiar, though not uncommon, in that one house has sons while another has only daughters. Statute law recognizes both sexes to be eligible for inheritance. The judges say, I also note that it is on record that the deceased treated his children equally. It follows that all daughters will get equal shares and all sons will get equal shares. However, due to the fact that daughters have an option to marry, the daughters will not get equal shares to the boys. I repeat that. However, due to the fact that daughters have an equal option to marry, the daughters will not get equal shares to the boys. As for the widows, if they were to get equal shares, then the second widow will be disadvantaged as she does not have sons. Her share should be slightly more than that of the first widow, whose sons will have bigger shares than daughters of the second house. That was the judge. That was the judge. Aggrieved with that decision, this matter was filed in the Court of Appeal, and the 3 judges had to grapple to get an answer to this question. And the judges looked at that question, that daughters are likely to be married by very rich people and have money. The men, the sons must work hard, toil hard. There's nothing for free for a man. Men must struggle. You check that, You graduate together with your ladies in the same class at the university. You finish exams, she gets married. By the time you are coming for graduation, she's driving a Lexus. She's living in a 7-bedroom house. You're still struggling, waiting for graduation to get a certificate for you to start toiling. So this is what the judge was saying. What did the judges of the Court of Appeal say? In page 13, while I do not doubt the discretion donated by the Act in matters where dependents seek a fair distribution of the deceased's net estate, I think the discretion, like all discretions exercised by courts, must be made judiciously, or to put it another way, on the sound legal and factual basis. The possibility that girls in any particular family may be married is only one factor among others that may be considered in exercising the court's discretion. It is not a determining factor, the judges are saying. In this particular case, however, I find no firm factual basis for making a finding that the daughters could be married. As shown by the undisputed facts above, all except one were unmarried or divorced in 1994 and were at an advanced age. 11 years later, when this appeal was heard, there was no evidence that the situation has changed. It is also an undisputed fact that the deceased treated all his children equally and never discriminated between them on account of sex. So the Court of Appeal is saying you cannot discriminate daughters on the basis of sex. More importantly, Section 40 of the Act, which applies to this estate, makes provision for distribution of the net estate to the, and I quote, houses according to the number of children in each house, but also adding any wife surviving the deceased as an additional unit to the number of children. The judges said a house in a polygamous setting is defined in Section 3 of the Act as a family unit comprising a wife and the children of that wife. There is no discrimination of such children on account of their sexes. Section 40 and Section 3 talks of children. It does not talk about their gender. It does not say boys or it does not say girls. So the judges are saying you cannot discriminate children because of that. The judge proceeds and says, I think in the circumstances of this case, there is no considerable force in the argument by Mr. Gisheru that the estate of the deceased ought to have been distributed more equitably, taking into account all relevant factors and the available legal provisions. I now take all that into account and come to the conclusion the judge is making the final orders that the distribution of the land, which is the issue falling for determination, must be set aside and substituted with an order that the net estate of 192 acres of land be shared as follows. So the Court of Appeal vacated the orders of the High Court. The High Court, remember, argued that daughters are likely to be married, so they can't get equal shares with their brothers. With their brothers. What did the judge say? A, 2 acres for the farmhouse, now commonly occupied by all members of the family, to be held in trust by the joint administrators of the estate. 2, 30 acres for the first widow, Jane Rono. C, 30 acres for the second widow, Mary Rono. D, 14.4 acres for each of the 9 children of the deceased. All the children whether they were, remember there were 6 daughters, some married, some unmarried, and 3 sons. Each were given 14.44 decimal, equal. This is the judgment of the Court of Appeal. This is the year 2002. This has been brought into the constitutional provisions of the Kenyan Constitution now. Everybody is equal before the law. You cannot discriminate a child based on gender. Everybody is equal before the law. Whether disabled, whether girl, whether child. This was a landmark ruling, a judgment of the Court of Appeal. What Omari is asking and Court Helicopter is asking, are you as brothers aware of this judgment? That your sisters, whether they were married, they have a right to inherit that land. 2, have you subdivided land and given yourselves title deed to the exclusion of your sisters? Those title deeds will be revoked. The grants that you got, removing your sisters from in place, those grants will be revoked. Those sisters who were dispossessed by their brothers, you go to an advocate, you file what is called an application to revoke the grant that gave only your brothers land to the exclusion of your sisters. If the grant has been completed and title deeds have been issued. 2, if the succession is proceeding, your parents have died, you will go to an advocate. You file what is called objector proceedings and say, we are daughters, I'm a daughter, although I'm married, I was born, you produce your marriage, you produce your birth certificate and say, I am a child of my father. The property, I'm a beneficiary in this matter. What does this mean? When people die, when parents die, the area chief, and this is a warning from Court Helicopter, the letters from the chief, normally chiefs write letters identifying only the wife, the spouse, and the male children, without disclosing that the deceased had girls in place. If any chief does that, that is a reason for that chief, a disciplinary measure to be taken, and that chief will be sacked. From Court Helicopter, we give notice to the chiefs that any time somebody dies, the letter you write that starts the process of succession, you must include every child, including daughters, whether married or not married. Failure to it is a criminal act and chiefs can be arrested. 2, the sons who go hiding and lying that they were born only sons, there was no daughter, your time is up. The title that you have will be revoked. The boundaries that you have will be revoked. Many homes, when the father and the mother dies, the sons subdivide the land to the exclusion of the daughters. The daughters can't even come to lay a wreath of flowers on the graves of their father because they have a problem of relationship between them and their brothers. What does this mean? The boundaries that we have right now, if you dispossessed your sisters because you thought they were married, you are lied. How about those sisters who do not want the property? If you don't want to be given a property of your father, you must come to court. You swear an affidavit that you don't want that property, you come to the High Court or the Magistrate's Court and you raise up your hand and say, me, I don't want that property. That is the only time your brothers can have land, because you have shown that you have no interest in that land. The case of Rono, it was about the decision based on customs. Every custom in this country, the Luyas, the Kisis, the Luos, the Kalenjins, the Kambas, the Mijikenda, all these tribes do not allow girls to inherit. This is now what we call cultures that are repugnant to morality and constitutionalism. Any traditional custom that is not allowing the girls to inherit the properties of their father, that culture is repugnant to morality. It has no space in the current Kenya, where brother and sister, all of them are equal. Those clinging to customs, those clinging to taboos, those clinging to old age practices, your time is numbered. I know the traditionalists, the male chauvinists who think that daughters cannot inherit. Your time is up. You either pack and leave and look for your country, because the Kenyan Constitution provides for equality of sexes. Tribe or no tribe, tradition or no tradition, taboo or no taboo. Wacha nieleze kwa Kiswahili hapa. Sasa sheria inasema watoto wasichana wana haki ya kupata shehena ya kutosha inayolingana na ndugu yake kijana ambaye wote ni watoto wa marehemu. Wasichana na wavulana wote wako sawa. Hakuna vile utanyima watoto haki yao ya kurithi mali ya baba yao, ya kurithi mali ya mama yao, kwa sababu eti wao ni wasichana. Huwezi sema ati wataolewa. Hayo yamepitwa na wakati. Sheria ya katiba inasema mila na desturi ambazo hazikubali hayo mambo, basi hizo mila hazitakubaliwa. Today, out of 10 to 10, the chiefs get 0 out of 10, because they are the biggest problem in terms of dispossessing daughters, women, girls from the property of their fathers. What about the courts? The courts, we give them 10 out of 10, because now no succession can proceed without all the children being in court. They demand that the sisters who don't want the land must come in court. From Court Helicopter, we have told you it is now very clear all children are equal. No child is a child of a lesser God. My sisters, the Gen Zs, you are equal. As daughters, you are equal to your brothers. Wakili Dan Omari, telling it as it is. Keep watching. More episodes are coming related to this matter. Thank you.